for those of you who follow everything, what Mr. Webb was talking about is the Bijan case with the Park Police shooting just a few blocks from here. And thank you for your work with them on that. I'm incredibly frustrated along with Senator Warner, Senator Kane, Senator Grassley on the other side, and others who have really pressed the Department of Justice to finish the investigation.
We have all seen the court dramas on television and in the movies. A dashing attorney making a passionate argument to a jury, delivering opening or closing arguments. And perhaps the most familiar phrase occurs at some strategic point in the trial when the attorney says with impassioned emphasis the familiar phrase, perhaps even more familiar than a promise to take the case all the way to the Supreme Court, if necessary, just those two simple words, I object. While it may certainly be a dramatic scene, even in a real courtroom, there is actually a significant reason why an attorney is actually required to say those words. Certainly, it is a way to break the rhythm of oral testimony that may be adverse to your client's interest, but when it comes to taking that next step of raising an issue for an appeal, with what attorneys describe as an assignment of error, there is a requirement to preserve your objections in the court record, because not even the Supreme Court is going to take the time to pass a voluminous record to discern any error that may have worked to the prejudice of your client. And that's what makes a recent rather controversial case, no matter where you may happen to stand on the central issue of abortion, because in a rule of law, Reverend King had suggested, an injustice anywhere is a threat to justice everywhere. And while today it may work to the detriment of your enemy, tomorrow that same rule can be used against you, too, my friend. Imagine for a moment a very simple example. You have been charged with a moving violation, perhaps blowing a stop sign, or making an improper turn, and at the time of the violation, you had been given a citation and been notified that your presence was required at some later date for an appearance at trial. In the law this is referred to as notice, which is a part of your rights to due process, under the 5th and 14th Amendments. You have been alerted to the pendency of a legal action, because you have a right to know the charge against which you are required to defend, just as you have a right to confront your accusers. And in a more serious context, like the charging of a felony count in an indictment, you have the same right of notice regarding the specific charge under a codified criminal statute, for which you shall be prosecuted at trial in court. Some criminal statutes, like conspiracy to violate civil rights, codified at 18 U.S.C. Section 241, have only one provision, and is punishable as a felony with a prison sentence up to 10 years, and/or fine. However, other criminal statutes are far more complex, detailing sentencing recommendations for first offenders, for repeat offenders, and may include other sentencing enhancing provisions, as is found under the Freedom of Access to Clinic Entrances Act, or FACE Act. And in a recent trial involving these two criminal statutes, by all accounts, the indictment had charged only 2 counts of offenses against the defendants. However, at trial, the prosecutor had abandoned the charge for conspiracy to violate civil rights, which he has a perfect right to do, in prosecutorial discretion, but to obtain the sentencing penalty for which he had desired to provide a deterrent effect, he decided to drop his plan to prosecute the defendants for the first offense that had been named in the indictment, carrying only a maximum penalty of 1 year in prison, and had replaced the charge with a sentencing enhancement provision that carried a maximum penalty of up to 10 years in prison. Now, place yourself in these shoes, and imagine that you had prepared to make an argument against 2 charges in an indictment, were relieved that the prosecutor had decided not to pursue the most serious charge, and had opted to prosecute for the lesser offense, for which you had prepared your defense arguments. But suddenly, just when you had been lured into a false sense of security, you learned that the prosecutor had actually decided to seek the maximum penalty under a provision you had no knowledge that you had violated. Imagine, again, going to court for a moving violation, expecting to return home with the thrill of victory, or the agony of defeat, but being convicted of a capital offense and immediately sent to death row. Well, remember that scene in the movies or television court drama? where the dashing attorney was making a passionate argument to a jury, delivering opening or closing arguments. Remember that most familiar phrase that most often occurs at some strategic point in the trial when the attorney says with impassioned emphasis the familiar phrase, perhaps even more familiar than a promise to take the case all the way to the Supreme Court, if necessary, just those two simple words, I object. Those facts, were you that attorney, would be your cue to deliver your Oscar-winning performance before the court. Does it make a difference if this injustice occurred against your political adversary? Would you be morally outraged only this had occurred against you or your friends? That is now the matter before the federal court for sentencing in the matter US v. Handy, and, like in a wedding ceremony, counselor, if you have any objections to this union, speak now, or forever hold your peace.
This message was approved by Major Mike Webb. Honest.